Okay, the Illinois State Constitution. Application to drug forfeiture laws. The Illinois Supreme Court has held that in prosecutions under the Drug Asset Forfeiture Procedure Act, this section guarantees the owner of property sought to be forfeited a right to a jury trial. The reason is that such attempted forfeitures are a kind of interim civil asset forfeiture which existed under common law and historically included a right to a jury trial. I think it's just one way for the Nazis and the cons and criminals and cunts of society, to take your drugs and use it for themselves for free instead of due process. An Illinois appellate court decision said that another forfeiture law, which provides for a judge alone to determine whether property of a person charged with a drug crime is subject to forfeiture due to its maintenance with drug-derived funds, did not violate the defendant's right to a jury trial. In that case, the forfeiture occurred after the defendant was convicted of drug racketeering, and the appellate court panel said this was only a sentencing decision. The historical right to a jury trial applies to the conviction phase of a trial, not to sentencing. Statutes on jury trials. The General Assembly can expand the right to a jury trial to cover more kinds of cases than are constitutionally guaranteed. At present, an Illinois law guarantees the right to a jury trial to every person accused of a criminal offense unless the defendant understandably waives that right in open court. The right to a jury trial does not automatically extend to new kinds of civil proceedings that were not known to the common law, such as those under the Workers' Compensation Act, Environmental Protection Act, or consumer fraud and deceptive business practices. Such as those under the Workers' Compensation Act, Environmental Protection Act, or consumer fraud and deceptive business practices. Section 14. Imprisonment for debt. No person shall be imprisoned for debt unless he refuses to deliver up his estate for the benefit of his creditors as provided by law, or unless there is a strong presumption of fraud. No person shall be imprisoned for failure to pay a fine in a criminal case unless he has been afforded adequate time to make payment in installments if necessary and has willfully failed to make payment. The first sentence is taken from the 1870 Illinois Constitution. The second sentence on paying fines was new in the 1970 Constitution. A person may not be imprisoned for failure to pay a debt that was not fraudulently contracted, even according to a majority of a panel of Illinois appellate court judges, if the person is unable to pay because he refuses to work. But a divorced parent can be imprisoned for contempt for failure to pay court-ordered child support. And yet the judge dismissed me when I put all of it before her again in January, her judgment to enforce. But a divorced parent can be imprisoned for contempt for failure to pay court-ordered child support, as can a person who has committed a legal wrong involving malice and failed to pay a resulting judgment. Spousal support, yes. A provision in the Unified Code of Corrections provides for paying fines in installments if necessary. May God give us discernment, we the people, especially Illinoisans. Peace out. Have a great day. Toodaloo.